Hi guys, welcome to the most awaited program News in 30 minutes. A lot of students were worried and a lot of students were messaging about this analysis program, which I realized the importance, after this break. So News in 30 minutes is not going to stop. So don't worry about it. However, the frequency of the News in 30 minutes will reduce because we are in the prelims window. Okay, because most of the students are preparing for prelims sincerely, so we have to give our efforts and our entire energy on prelims for helping our students. So I will not miss out on any article. Okay, however, I will also not be able to do it on a daily basis, so but I will cover all the articles and not miss out on any articles. So don't worry about it. Don't think that it will stop abruptly. Okay, and I am really happy that so many of the students are diligently watching these series of News in 30 minutes. News in 30 minutes has its own following, which I appreciate, and I do know that you people want to develop that thinking mindset, and this mindset is very important for your mains exam. So I hope you continue doing it. Again, before we start off, I'm telling you, this initiative is not a substitute to newspaper reading. Please make sure that you continue reading your newspapers. Along with that, you make use of this. Okay. A lot of students keep asking me, prelims is near, so should I stop reading newspapers? I personally feel newspaper is an habit. So stop asking that question. Please read newspaper to enrich yourself as a human being, to enrich yourself as a learned individual, rather than thinking that you're using that in your exam. Okay, so with that, let us start off with some of the important issues from 20th to 29th February of 2024. The first issue, a lot of students messaged, to give some clarity on this. So here we go. Go back to dictionary meaning of forest, tells the Supreme Court. Okay, the bench says the expression forest will continue to have a broad and all-compassing meaning for the time being until the final judgment is done. The order comes to the petitions challenging the amended Forest Conservation Act, Forest Act of 2023. Okay, so let me give you a background of what this issue is all about. Okay, so there was something called Forest Conservation Act 1980. Okay, and this Forest Conservation Act 1980, it basically restricted non-forest use in forest. Okay, so it stopped, or it created a procedure for any type of deforestation, or it created a procedure for any type of forest conversion. Okay, so this deforestation and forest conversion can happen, but it can only happen within the procedure that is established in the Forest Conservation Act. Okay, so this was an act that was helping India to have a forest cover, a very good forest cover, okay, to stop rampant deforestation. Okay, now let me just give you a statistics of how important this act has been. Okay, if you take the conversion of forest land, and if you see the conversion of or diversion of this forest land, okay, on two aspects I will tell you the diversion. The first aspect is from 1951 to 1975, and the second is from 1980 onwards. Okay, from 1980 onwards. So if you take 1951 to 1975, the amount of forest land that was diverted was 4 million hectares. Whereas if you take 1980 onwards, the amount of forest land that was diverted was just 22,000 hectares. Okay, so look at the difference it has made with regards to this Forest Conservation Act. Forest Conservation Act has been the most successful environmental legislation of India. Okay, so this is why we have to emphasize on the importance of this act. Okay, so from 4 million hectare, it is just 22,000 hectares that have been diverted with respect to Forest Conservation Act. So this is where the act is very important. So I hope you got the background of the importance of this Forest Conservation Act. Okay. Now, one more thing that you should remember is during there comes a scenario where now the Forest Conservation Act, you have the Forest Conservation Act 1980. In this, you have something called forest. We have to conserve the forest. Now the debate starts, what is the definition of forest? Because in the act, the definition of forest is not given. So what is the definition of forest? So when this debate of what is the definition of forest comes, the government says that the forest falls into two categories. The government says that the forest falls into two categories. One is declared forest. One is declared forest. And the two is the forests. Okay, the land recorded as forest. The land recorded as forest in government record. Okay, so these are the two meanings of or definition of forest. This is what the government tells. Okay, however, now this becomes a little narrow interpretation of what forest is. That is why in 1996 there is a very famous judgment that comes. The name of this judgment is T.N. Godavarman Thirumulpad judgment. Okay, there is a judgment that comes in 1996 in in Supreme Court. That is the T.N. Godavarman Thirumulpad judgment. And in this judgment, the court will take the expanded view. It will take the expanded view of forest. And when it takes an expanded view of forest, it tells forest should be defined as the dictionary meaning. Forest should be defined as the dictionary meaning of forest. So when court interpreted forest in such expanded view, all those forests that are out of government record, now also these forests comes under the ambit of the forest. Then came the concept of deemed forests. So deemed forests are those forests that are present on those lands that are not recorded, that are not in the government records. Or we can also say deemed forests are those forests that are present in private land. Okay, so like this, in the T.N. Godavarman Thirumulpad case, the Supreme Court has taken the expanded view of forest, which is dictionary meaning of forest rather than this narrow interpretation of forest. Okay, so this was the issue that has up to the 1996 or up to 2023, this is how the meaning of forest was carried out. Okay, then came the Forest Amendment Act. Then came the Forest Amendment Act 2023. In this Forest Amendment Act 2023, they substantially diluted the meaning of forest. They substantially diluted the meaning of forest, and they brought down the meaning of forest to the meaning of they brought down the meaning of forest to the two things. That is, one is declared forest, another is those land records or the land recorded as forest in government records. See, they substantially diluted the definition to just declared forest and the land recorded as forest in government records. So they negated the Godavarman Thirumulpad case, that is expanded view of forest. Okay, now the Supreme Court reviewed this particular the Supreme Court is reviewing, currently it is still reviewing. So the Supreme Court is currently reviewing this particular Forest Amendment Act. Now when it is reviewing the Forest Amendment Act, the final judgment is not yet given. However, before the final judgment is given, for now, the government should consider the Godavarman Thirumulpad case. Okay, the definition of forest as interpreted in the Godavarman Thirumulpad case, that is the dictionary meaning of forest, should be considered until the final ruling by the Supreme Court is what this article is all about. So I hope you got the clarity of what this act is and the headlines telling go back to the dictionary meaning of forest. I hope now you understood why the Supreme Court is telling to go back. Correct? So because the Amendment Act has narrowed down or substantially diluted the meaning of forest. Now, when the government was asked why is it diluted the meaning of forest, the response of the government is, one, it wants a proper clarity of what is the meaning of forest, and because it wanted clarity, the government has amended this act. That's the first reason that the government has given. The second reason the government has given is the private individuals are very skeptical in growing plantations or trees. The reason why they are not encouraged to grow plantations or trees is, the moment they are growing trees or plantations, this will come under the dictionary meaning of forests, and the government can intervene. And when the government can intervene, the private individuals will not have any incentives to grow, because it is creating that level of resistance among the private members to put their land for forestry use. This is another reason why the government says that it is amending this particular meaning of forest. And the last is, if we have to improve our forest cover, we need the participation of both public and private. And if we need this forest cover in order to make our promises of Paris Agreement. Okay, make our promises of Paris Agreement, where we have promised that by 2070 we will have carbon neutrality. So if we need that, we need enormous amount of carbon sink, and that carbon sink will come through forest cover, and the forest cover can only come by the participation of private and public individuals together. So if our commitments to Paris Agreement has to be successful, if the private players have to be incentivized, and if there has to be clarity and what exactly forests mean, then this amendment was necessary. Okay, so that is what is the justification given by the government of India. Okay, however, the review is still going on. So until the final judgment is given, the ruling that is given by T.N. Godavarman Thirumulpad judgment will stand. Alright, so this is the overall issue regarding the Forest Conservation Act 1980. Okay, however, as I told you, this act has been one of the most successful acts in the history of India and stands out as one of the most important environmental legislations of India as well. Okay, so this is about the first issue. I hope you got the clarity. Let's move on to the next issue of the day. The next issue of the day is again very interesting issue that definitely will come in the mains exam of GS2. There is very high chances. So in mains, we can actually predict the type of questions that will come, because it will always be issue based. Now this is one more very important issue. As you know, judiciary is an important theme. One question in GS2 will always come on judiciary. So this, should India have regional benches of the Supreme Court? Okay, so this is an argument or the debate that is going on. Why is this debate going on? Because the Parliamentary Standing Committee of Personnel and Grievances has conveyed to the Lok Sabha that the Law Ministry has endorsed its proposal in order to have Supreme Court's regional benches throughout India. Okay, that is why this debate has started. Okay, so it has conveyed to the Lok Sabha that its proposal to have regional benches throughout India of the Supreme Court is being considered by the Law Ministry. So it is still being considered. It is not done right now. So since it's still being considered, they are weighing in the pros and cons. Hence the debate of should India have regional benches of the Supreme Court. Again, a very interesting article is given. You can read it out. The entire article itself will become a very good answer. Okay. Now let me elaborate on this. The first, let me argue against. Okay. I'll argue against because one, I will say that the virtual earrings, okay, the frequency of virtual earrings are increasing post-COVID. Because after the pandemic, the virtual earrings are increasing. This virtual earrings can act as alternative to regional benches. Okay, this virtual earrings can act as alternative to regional benches. The second reason why I want to go against this, the Chief Justice of India has also indicated that all courts must shift to virtual earrings. Okay, so because the virtual hearings is giving greater emphasis, that in turn will remove the geographical proximity or the geographical disadvantage. Hence, the regional benches may be redundant. That is the interpretation. The next is the third one. The third is regional benches. Okay, regional benches may contribute to conflicting precedents. It may contribute to conflicting precedents, and this conflicting precedents may result in increased litigation. That is what they are trying to tell is, if there are, let us say, 4 regional benches, if Y and A are giving conflicting judgment or conflicting interpretation of law, then this conflicting interpretation of law will in turn increase the amount of litigation, because there is again gray areas, there is again lack of proper interpretation of law, so that confusion will again arise. So that as you create regional benches, there will be conflicting precedents, and that in turn will increase litigation. That is another reason why regional benches should not be there. The fourth reason given is balkanization of Supreme Court bar. Balkanization of Supreme Court bar. Okay, so this is again the an argument against having regional benches. Okay, the reason why I'm giving you argument against regional benches is this argument is relatively weaker. Okay, the argument of having the regional benches for is very, very important. Okay, the reason is because that makes more sense. There is more points there. The government standing is also there, so you should also go along with the government stand. Hence, for is more sensible as well as reasonable option for us to go ahead. So the first reason why we have to go ahead for having regional benches is the study conducted by the legal expert. The study conducted by a legal expert called Nick Robinson. Okay, Nick Robinson has conducted a study in 2011. He has conducted a study in 2011. In this study in 2011 that he has conducted, he has concluded that majority of the case that comes to Supreme Court comes from Delhi. Now, why is majority of the cases of the Supreme Court coming from Delhi? Because of geographical proximity. So the conclusion is there is geographical bias for the cases taken by Supreme Court. Why? Because it is based on proximity. So this shows that we need to have regional benches to overcome this geographical bias. So that is the first point. Again, see, very sensible point. The second point the author makes is by increasing or establishing regional benches, okay, it will increase the number of judges, it will increase the number of advocates, and hence by increasing the number of judges and number of advocates, it will give the boost to the entire judicial system. Right, so the entire judicial setup or the entire judicial infrastructure itself will be enhanced when you have high number of benches, which in turn will have judges and advocates. So that is the second and a very valid point made by the author. The third point is basically on this particular aspect. Okay, how do we negate this? Because this is again very sensible point where you say having regional benches can have conflicting precedents, that in turn can have increased litigation. How do we overcome this problem of conflicting precedents? For this, the author gives a very interesting view. This recommendation has been given by the Law Commission report. This recommendation has been given by Law Commission report, the 95th as well as the 255th. Both the reports have given this recommendation, and this recommendation is inspired from France. Okay, France follows this type of judicial separation. So what the author says is you can divide the Supreme Court into two parts. One is a separate court of appeal, and the second is courts of cassation. Casation. Okay, courts of cassation and separate court of appeal. Now see, this separate court of appeal will deal with constitutional matters, and this court of cassation will deal with non-constitutional matters. Okay, so when there is proper separation of the functions of Supreme Court, when this is dealing only with the constitutional matter, then the interpretation of law will always be in the hands of the separate court of appeal, and the courts of cassation will only take up non-constitutional matters. So this division of the functions of the Supreme Court will help overcome this problem of conflicting precedents. So let us assume that even if there is conflicting precedents within the court of cassation, let us assume that if there is a conflicting precedent, okay, between the regional benches of this court of cassation, then this conflicting precedent in the regional benches of this court of cassation will be resolved by this one separate court of appeal that is there in Delhi. Okay, so this is how this problem can be resolved. Okay, very beautifully written. Again, that is the third reason. Okay, the fourth reason that the author says is, the fourth reason why we should have regional benches is, again, rather than thinking that it will result in balkanization of Supreme Court bar, the author says you should look at it as it provides greater opportunities. It provides greater opportunities and will help in democratization. It will help in democratization of the Supreme Court bar. Okay, so this is how this particular, having the regional benches helps. Okay, so these are some of the, both analysis for and against the regional benches. Okay, so let me just summarize. The regional benches, the issue is happening because the Parliamentary Standing Committee has conveyed to the Lok Sabha that the Law Ministry has endorsed its proposal of having the regional benches for the Supreme Court. Here the author first argues against, tells that we are in the era where virtual hearings are going to be the norm. The CJI has also emphasized on virtual hearings. The regional benches will have or can have conflicting precedents that can increase the litigation, and further there can be balkanization of Supreme Court. However, there is also an argument where the author very nicely says that according to the legal expert in the 2011 study by Nick Robinson, says that majority of the cases that goes to the Supreme Court is from Delhi. Hence, we can see a clear geographical bias. Okay, and the next is regional benches, if established, will create number of judges and number of advocates, more number of judges and more number of advocates. Hence, this in turn will boost the entire judicial system. The next is the the conflicting precedents can be resolved by following the recommendation given by the Law Commission in the 95th and 255th report by implementing the same system that is done in France by dividing the functions of Supreme Court into the separate court of appeal that deals with constitutional cases and the courts of cassation that will deal with non-constitutional matters. And the last is the greater opportunities and democratization of the Supreme Court bar by having the regional benches. So again, a very, very well articulated article. Conclusion, the author says that yes, we have to establish regional benches. There is no, two minds about it. However, what we need to take care is the exclusive powers of the Supreme Court. The exclusive powers of the Supreme Court are preserved. We know that the Supreme Court is the guardian of the Constitution. It is the Supreme Court that makes sure that the Constitution is always held supreme and sovereign in India. So the exclusive powers of the Supreme Court are preserved and not in any way hampered. And for this, the author says Article 131, which talks about original jurisdiction. Okay. The next is Article 143. This talks about advisory jurisdiction. And the last is Article 32, which talks about writ jurisdiction. Okay, so these are some of the important things that has to be preserved. Under any circumstances, the Supreme Court's jurisdiction under 131, 143 and 32 should not be touched or should not be hampered. So this is the conclusion that the author gives. Okay, so I hope it was helpful and I hope you got a very good clarity. This is how you have to practice your mains preparation. It is not only about biarting. This is how you have to develop different dimensions. And you will get these dimensions not by just listening to the class, but reading newspapers. Reading on your own will help you develop the dynamicity in your thought process that will reflect in your answers. So I hope it was helpful. Let us go to the next issue of the day. The next issue is there is a new concept that is introduced in our Raisina Dialogue. Okay, so we have the Raisina Dialogue. Okay, this dialogue happens in New Delhi, and this dialogue happens annually. That is, every year it takes place. Okay, this happens with the help of Ministry of External Affairs plus Observer Research Foundation. This is a think tank. Okay, so Ministry of External Affairs along with Observer Research Foundation together will hold this Raisina Dialogue. I'm proud to say that one of my student also was representing this Raisina Dialogue. Okay, the next is this Raisina Dialogue started in 2016 and the 2024 was the 9th edition. And the special guests, there were many special guests. For example, there were 2,500 participants, and these participants came from almost 150 countries. Okay, and the basic objective of this Raisina Dialogue is it is a conference on geopolitics and geoeconomics. Okay, it is a group. It is basically a conference where they discuss about the geopolitics and geoeconomics. Okay, so in this Raisina Dialogue, when all the countries came, there was a new grouping that announced itself. This grouping is known as NB8. Okay, when they say NB8, it means Nordic Baltic Cooperation. Nordic Baltic Cooperation. And this Nordic Baltic Cooperation has a total of 8 countries. That's why they are given the name NB8. Okay, so now let us look at this from prelims perspective, because as you know, there are very high chances for this topic to come from prelims perspective. If you look at this, what is this NB8? You're looking one at Nordic countries. Nordic countries constitute 5 plus you're looking at Baltic states. Baltic states constitute 3. Okay, first let us look at the Baltic state. Okay, the Baltic states are Estonia, Latvia and Lithuania. Okay, these 3 together are known as Baltic states. Okay, all these Baltic countries are worried because of this Kaliningrad of Russia. Okay, Russia also has a border in Baltic Sea, so please don't forget. Okay, it has a border here as well as it has a border in Kaliningrad. Okay, anyways, barring that, we are talking about the Baltic states. We have 3 Baltic states: Estonia, Latvia and Lithuania. Okay, these are the Baltic states. The next is the 5 Nordic countries. We have discussed many times in our classes, but let us do it one more time. The 5 Nordic countries are Denmark, which is here and here. Greenland is also part of Denmark. The next is Iceland. The next is Norway, Sweden and Finland. Okay, so these 5 countries, the Denmark, Iceland, Norway, Sweden and Finland with Estonia, Latvia and Lithuania, this is what is known as NB8 countries. Okay, now the reason why they are forming a cooperation, the reason what they are giving, why they are forming a cooperation is basically because of, the first reason is Russia-Ukraine conflict. They are feeling threatened by the Russia-Ukraine conflict. So in this era of turmoil, they want to develop trust and cooperation. So that is the main reason why they say that this NB8 is formed. The second is they want to have joint forces in the face of aggression. In order to face off this aggression, they need to have joint forces, and hence they have formed this group of countries. Now, taken together, this NB8 countries would qualify not only as a country, their size would qualify not only for G20, their size would also qualify for G10. Okay, so what I'm trying to say is these countries have a very high economic prowess. They are good economic powers. Economically, they are standing at a very good point. So, in this way, NB8 grouping makes sense in order to come together, in order to ward off any type of conflicts created by Russia, especially in Eastern Europe, that can have a spillover effect in Nordic countries as well as in the Baltic region. Okay, so this is the main reason why this NB8 is formed. So I hope you got the clarity of what is this Raisina Dialogue, and I hope you got what is the clarity of this Nordic countries and Baltic states coming together, creating a cooperation unit known as NB8, and the reason for their formation. Okay, so this completes this issue. As I told you, this is more confined from prelims perspective rather than mains perspective. Okay, so let us go to the next issue. X factor. On the X appeal in the Karnataka High Court, basically when they say X, it means Twitter. Okay, so there is an appeal to the Karnataka High Court that the government has, attempted to create censorship. The government has attempted to create censorship. Okay, and the government has put a lot of internet shutdowns in different regions of India. Okay, so this type of complaint, the censorship and internet shutdowns, has been rising in different parts of India. And this article talks about how the government cannot use this. The government cannot use this arbitrarily. The government cannot use this arbitrarily. That is what is the entire argument. It cannot use this arbitrarily because there is a doctrine, and the doctrine is known as Doctrine of Proportionality. Okay, there is a doctrine called Doctrine of Proportionality. So this article mainly talks about this Doctrine of Proportionality. So the article very nicely talks about how the Doctrine of Proportionality is breached, and in different parts of India, the government is taking up a lot of internet shutdowns. Okay, the government is taking up a lot of internet shutdowns, and it is also creating a lot of censorship by restricting the social media companies from publicizing the content. Okay, however, the author says this cannot be done arbitrarily. It has to be done by the procedure established by law, and that whatever the actions the government makes should always be in conformance with the doctrine of proportionality. Now, what is this doctrine of proportionality? It is a legal rule to balance. It is a legal rule to balance government actions between the means and outcomes. So the government cannot influence means and outcomes. The government should always have a balanced view in the means and outcomes. So that is what is the doctrine of proportionality. So the government's actions, it is all about the government's actions. The government's action must be rational. The government's action must be fair. The government's action must be reasonable. See, these are the three important points why the doctrine of proportionality is important. So whatever the government action is, the government's action should always be rational, fair and reasonable. Only if it is rational, fair and reasonable, then it passes the test of doctrine of proportionality. Okay. However, the author again very beautifully gives a Supreme Court case. Okay, a Supreme Court case that is known as, it's a very famous case, you should know this also in your fingertips, that is Anirudh Bhasin versus the Union of India 2019. Okay, this case, in this, the doctrine of proportionality, in this case, the doctrine of proportionality is very nicely summarized. And the doctrine of proportionality is summarized as it constitutes all these things. Okay, what are all the different aspects that constitutes the doctrine of proportionality? The first is there has to be a legitimate goal. It cannot be arbitrary. There has to be a legitimate goal. Then you have to first consider all the alternatives before taking this type of shutdown or censorship. The third is there has to be appropriate cause. So there should be appropriateness, appropriate cause. The fourth is it should be absolutely necessity. That is, it should be absolutely necessary. The fifth is there should be least restrictive measure. We know that we are going to put the restriction, but that restriction should be of least nature. The sixth is support should always be by evidence. Okay. And the seventh is it is subject to judicial review. Okay. So all these 7 aspects should be considered for the doctrine of proportionality. This was what was declared in Anuradha Bhasin versus Union of India 2019. Okay, again, very beautifully written article. See how much information the author gives just in one small article. This can be used in your GS2 paper. You need not wait for them to ask about internet shutdown. You can definitely use this in weighing out different scenarios in your GS2 polity or GS4 ethics, as well as in your case study. Okay, a very good article done. Now, along with this Anuradha Bhasin versus Union of India 2019, other cases where this doctrine of proportionality was upheld was, one is Ranjit Thakur. One is Ranjit Thakur versus the Union of India. This was a very old case of 1987. So here also the doctrine of proportionality was upheld. Another case, the doctrine of proportionality was upheld was K.S. Puttaswamy versus the Union of India. K.S. Puttaswamy versus Union of India. This was in 2017. Okay. So in both the cases, the doctrine of proportionality was upheld, but the speciality about Anuradha Bhasin versus Union of India case was that the doctrine of proportionality was summarized. And the summarization of this proportionality constitutes these 7 characteristics. So I hope you understood what is this article all about, what is doctrine of proportionality, what are the Supreme Court cases that deal with doctrine of proportionality, and what are the different characteristics of this doctrine of proportionality. All right. So again, a very mains relevant article. So this completes the part 1 of the news in 30 minutes. Part 2 will be coming tomorrow itself. Don't worry about it. I've already done the video. The only thing is the duration gets very long. Because the duration gets very long, students usually don't watch such high duration videos. That's why I thought I will divide this into part 1 and part 2. Okay. So I'm just dividing the video into part 1 and part 2. Don't worry about it. Make sure that you watch this, make the notes completely, and then come and watch part 2 as well. Okay, so see you again in the part 2 of the video in some time. Take your time, revise the concepts, and I hope it was helpful. Please tell your students to make sure that they also tune in, get a good help of this, develop that mains mindset properly. Okay, and please make sure that don't forget to like, share, and subscribe, guys. Thank you so much. Again, let us see in the part 2 of this video. Bye.